our next question really has to do with a major injury. In fact, medical malpractice. A question came to us and they want to know just how do I know if I have a medical malpractice case? At what point do we, can you determine if you have a case?
Well, Morgan, that is a good question, and a lot of people ask that. We probably, out of 100 people that we see and consult with on an issue of medical malpractice, less than 5% actually have a case. But the short answer to the question is, if you think you might have a case involving medical negligence, then of course the first thing you need to do is consult a lawyer who is competent to handle a medical negligence case. And that lawyer then would interview you. He would get a history from you. He would then, or she would then order all of your medical records and then have those medical records along with your narrative of what happened reviewed by another physician. In Georgia, before you can bring a lawsuit against a doctor for malpractice, you have to have an affidavit from a physician who is competent to do the same kind of medical services that that doctor performed for you. So yes, you go to a lawyer first, you get the medical records, the lawyer calls in a physician to review the medical records, then you meet with the lawyer and the doctor and go over the facts of the case and what is in the medical records. I might add that as a caveat to somebody who thinks they might have a medical malpractice case, it really doesn't turn around what you say happened. It turns around what is in the medical records. Almost all medical malpractice cases turn around what is in the records and can it be proved on the records. If it can, then you have a medical negligence case.
All right, Wendell?
And then a lot of cases are excluded, even though there may have been malpractice, just because the injury was not severe enough to justify the financial outlay of prosecuting the case.
Okay.
And a lot
that's very true, but that begs a little more information. And,
okay.
and I don't mind sharing that with our viewers. Our General Assembly, in its infinite wisdom, has passed bills over the past several years that basically, on a case less than catastrophic, bar a plaintiff from having access to the courts because the laws have made it so difficult to get to the courts and made it so expensive to find out whether or not you have a case. That's what Wendell meant. If you have a case that's worth, just as a hypothetical, $50, $60, $75, $100,000, that means your injury in a medical malpractice context is not that great. And it's going to cost you probably $20,000, $30,000 or $40,000 to prosecute the case. So a lot of cases where there has been clear negligence on the part of a medical doctor cannot be brought simply because of the burden of the expense and the time and the effort and the energy and the money it takes to prosecute that case. And that's just the way it is. We don't take a medical malpractice case unless they meet some threshold, which generally speaking is that the case would be worth $300,000 to $400,000. That's the hard, cold reality of the situation with regard to that question.